Good afternoon, and thank you for joining us. Welcome to course number 3922, Florida's Commercial Real Estate Receivership Law, Substantively Changes July 1st, 2020. Are you prepared? Today's presentation is brought to you by the Business Law section of the Florida Bar, and this section has produced several informational CLEs as part of our COVID series that began on April 30th and are available on the section website for viewing at no cost. So we also invite you to get onto our website and take a look at those. This presentation is also going to be added to our catalog that is available on our website, and it will also be available for no extra cost, just as you've been able to join us today. We also have a COVID-19 resource page that we continue to update with the most recent information, so please take a look at that. And lastly, we would like to invite you to become a member of the Business Law section. You'd have access to discounted CLEs, networking opportunities, and we would love to have you. So if you have any questions about that or need any more information on that or any of the CLEs that we have produced, please visit our website or don't hesitate to contact me. My information is on the Florida Bar website, Business Law section page, as well as the Business Law website. So please let me know if I can be of any help. Our program today is going to be 1 hour, and then we will also have questions that we will try to answer as many as possible at the end of the session. If you do have a question, please use the question and answer box that you can find located at the bottom of your screen. And then we will be going through as many questions as possible at the end of this presentation. The presentation is going to be moderated today by Andrew Layden. And Andrew, I'm going to go ahead and turn it over to you. And thank you all for being here.
Wonderful. Thank you, Stephanie, for all your help putting this together. We appreciate it. As Stephanie mentioned, my name is Andrew Layden. I'm a partner in Baker Hostetler's Restructuring and Bankruptcy Group in Orlando, Florida. I have the pleasure today of moderating a really excellent panel, and I'm honored to be in that role. Without further ado, I will go ahead and introduce our panel. We have a lot of substance to hopefully get through today, and we will go ahead and jump right in. As Stephanie mentioned, the CLE number for today's presentation is 3922, and questions can be asked via the Q&A feature at the bottom of the Zoom. And if we have time, we will address some of those questions. I'll turn now to our panel. I'll introduce them from left to right. Judge Mindy Mora is a U.S. Bankruptcy Court judge in the Southern District of Florida in the West Palm Beach Division. She was appointed in April of 2018. She graduated from George Washington University in 1979 and received her law degree from New York University in 1982. Following that, she practiced in the areas of bankruptcy and commercial finance for approximately 36 years prior to her appointment on the bench. Judge Mora is a fellow in the American College of Bankruptcy, as well as the American College of Commercial Finance Attorneys. She previously served as the chair of the Business Law section of the Florida Bar, which, as we all know, represents the interests of more than 5,000 business lawyers within the state of Florida. Throughout much of her legal practice, Judge Mora has been active in the development of Florida's commercial laws, and the UCRERA law that we'll discuss today is no exception. She was on the BLS task force that put together that law. Pictured next to Judge Mora is Judge Edward LaRose from the 2nd DCA in Tampa. Judge LaRose attended Boston College University for undergrad and received his JD from Cornell Law School in 1980. Following that, he practiced in the private practice for approximately 35 years, including at Trinum Kemker, where he headed the firm's employment law practice group. He was appointed to the 2nd DCA in 2005. Judge LaRose has served on the Business Law Section's Executive Committee and has been active on a number of committees, including, again, the UCRERA Task Force that was instrumental in this law. Pictured next to Judge LaRose is Kenneth Morena from Damien and Valori in Miami. Mr. Moreno is a federal court-appointed receiver, receivers counsel, business litigator with extensive experience in both federal and state court at the trial and appellate levels. He has spent most of his career representing federal and state court-appointed receivers, monitors, and other fiduciaries, as well as defrauded investors in government enforcement actions brought by the SEC, CFTC, and FTC based on securities, commodities, and consumer fraud, and in asset recovery litigation and class actions related thereto. Mr. Moreno was the chair of the BLS task force on the Uniform Commercial Real Estate Receivership Act that we're discussing today. And finally, Manuel Farach advises clients in complex real estate and business matters with a focus on real estate and creditors' rights work. He is board certified by the Florida Bar in real estate law, business litigation, and appellate law. He's one of only 15 members of the Florida Bar who is simultaneously board certified in all three practice areas. He also authors numerous legal publications, including Florida Real Estate Law, which is the real estate component of Thomson West's Florida Practice Series, and publishes the Florida Real Property and Business Litigation Report, which is the highly read weekly compilation of state and nationwide real estate and business cases. Mr. Farach is a fellow in the American College of Real Estate Lawyers and has served on the executive council of multiple divisions of the Florida Bar, including the business law section and the ADR sections, and also the real estate, real property section. So thank you to all of our speakers. We really have a wonderful panel. When we were putting this together, we made our dream team of panelists, and we were fortunate enough to get every single one of them here today. So thank you to all of them for their time and effort. I would like to go next. We'd like to recognize the legislative sponsors that helped make this a reality. And to introduce them, I will hand it over to Manny Farach.
Good afternoon, everyone. As you know, the business law section is very active on business matters before the Florida legislature, but we can't do it without our friends in the legislature. We've got two of our friends with us today, Senator Berman and Representative Beltran, the two sponsors of the bill, respectively, in the Senate and the Florida House of Representatives. Let me introduce them to you. Senator Lori Berman represents District 31 in the Florida Senate and has been a member of the Florida legislature since 2010, first in the House of Representatives and in the Senate since 2017. She is a member of the Florida Bar and a graduate of Tufts University and George Washington University Law School with an LLM from the University of Miami. Senator Berman, thank you for your service to the citizens of the state of Florida. Michael Beltran represents Florida House of Representatives District 57 and has been a member of the House of Representatives since 2018. He is a graduate of the University of Pennsylvania and Harvard Law School and also a member of the Florida Bar. Representative, thank you for your service to the citizens of Florida. Senator Berman and Representative Beltran, if you'd like to say a couple words about the bill itself. And again, thank you for your service. And we'll start with you, Senator Berman.
Thank you so much. Thank you for having me here today on the panel, Manny. I really appreciate the opportunity to talk to you. As he said, I've been in the legislature since 2010, and I will tell you this bill had some of the most interested stakeholders of any of the bill that I've worked on. We had to get the real property section to agree. We needed the Florida bankers to agree. We needed the land title groups. So it was a little bit of navigation, and including within the section, there was a lot of discussion about how to make this bill correct. I'm really happy that we all were able to work together and get the end product that we got. We are now one of only 9 states that have the Uniform Commercial Receivership. And I can't stress enough how timely and important it was to get this with the COVID crisis, because we're going to see the impacts on commercial real estate. And we're going to need to have a procedure in place so that people can file for receivership and maintain the property. So I also wanted to say a special shout out and thanks to the Metz Husband and Doughton Law Firm particularly Amy Diaz-Lyon, Doug Bell, and Jim Doughton. They really helped us shepherd this bill through, and along with the section and the people who came to Tallahassee, thank you for getting this done. And I'm glad that we're having this panel today so that we can start to really implement this new law. Thank you.
Thank you, Senator Berman. Representative Beltran, do you have a couple words you'd like to say?
Yes. Thanks, Manny. I appreciate it, and it was great to work on this bill. I actually, Doug Bell brought the bill to me, and I kind of want to echo Senator Berman's remarks about them. They gave me a great bill. They'd worked out a lot of the issues. I know there were a few issues during session, but really a good finished product. And Manny as well. Thank you for your efforts. This was a great bill, which kind of came to me, and it was an issue that I had experienced in my practice on several occasions, where I was representing a creditor and you had a debtor in a foreclosure who was pocketing rents and not maintaining a property in the way that a prudent business person would be doing, and they were instead using those rents to finance a litigation effort to drag out a foreclosure and pay their lawyer, but not pay their creditor. And so that was very frustrating. And I think this framework, this procedural framework, will help to implement appropriate remedies, particularly given the fact that we may have an increase in this type of litigation going forward, and really to maintain these properties and ensure that the properties do not become dilapidated to the detriment of the community. I think there's a public interest, as well as our business litigation mindset. And so thank you, everyone. It was great to work on this bill, and you guys have a great panel now, so I'll shut up and let them speak.
Thank you, Representative Beltran. Andrew, that's all I have for the introductions.
Thank you, and thank you again to Representative Beltran and Senator Berman. I will go now to the substance of our presentation. The slide you should see now is the agenda. We've basically broken it up into three pieces. First is a brief overview of where Florida law was prior to July 1 of this year, when UCRERA became effective. Then the main part of the presentation will be an overview of the provisions of UCRERA itself, and we will follow that with some commentary on how our panelists think current practice could be affected by this new law. So the first thing I will do is, give you a couple quick facts here about UCRERA. If you're not aware, the effect of the law is it creates a new chapter of the Florida Statute 714 titled Uniform Commercial Real Estate Receivership Act. That's what we'll be discussing today. The effective date's July 1, 2020. The bill was signed into law June 27th, I believe, by the governor, and it does not apply if the receiver was appointed prior to July 1, 2020. As Senator Berman mentioned, there's now 9 states that have some version of the uniform law in effect, and it's also been introduced in Connecticut, but not passed at this point. So next, what I'll do is we will talk a little bit about the pre-UCRERA state of Florida law, and I will ask Manny Farach and Judge LaRose to address that. I know that's a broad question, and on top of that, I'll ask you to do it in maybe 5 or 6 minutes. So I will hand it over to you guys for that.
Thank you, Andrew. Judge LaRose, how are you today?
I'm doing great.
Great. There's a couple of slides that we will deal with. There's the one called Receiver for What, and also the pre-UCRERA state of Florida law. Judge Rose, I'll deal with Receiver for What, and maybe you can talk a little bit about the pre-UCRERA state of law. The Receiver for What, the question is really, under what circumstances are you going to get a receiver? Typically, you're going to have situations involving some form of waste. Examples: receiver of an LLC, a corporation, or partnership. That's statutory 605.0704. Post-judgment receivers in need of execution. And of course, receivers of trust estates or trust funds. Now, prior to UCRERA, Judge LaRose, what did we have in terms of the state of Florida law?
Well, basically, receiverships are an equitable remedy. And on this slide, you'll see a fairly lengthy quote from one of my colleagues here at my court. And the purpose of the equitable remedy was to preserve the status quo, preserve the property, collect and apply rents and profits. But as a matter of our common law, because it was an equitable remedy, it is to be approached very cautiously. And it's in derogation, the appointment of a receiver is in derogation of the common law. So it has to be strictly construed because you are impacting the ability of a property owner to control his, her, or its interest in the property. And I think it's clear in the bold part of this, this quote from the second DCA, that you have to show, if you're moving for a receiver, you have to show a serious loss that is ongoing to the property, some sort of waste, and that you as the movant have a clear legal right to the property. And I think that although this is a 2013 case, it certainly reflects the state of receivership law prior to your career.
It takes us all the way back to Carolina and Portland Cement, doesn't it? And that's what, 1930, a Florida Supreme Court case, which really sort of makes you think as to why we really needed UCRERA or something similar to UCRERA. Let's talk about the entitlement to appointment of a receiver. Along the lines of what Judge LaRose said, there are some examples of waste or other equitable bases for appointing a receiver: deferred maintenance that imperils the property, stealing or misapplying rental income, what Representative Beltran spoke about, failing to pay another mortgage so that the mortgages would have to defend against each other, when you've got a construction project that isn't finished but needs to be finished, and to protect the property during protracted litigation. Now, Judge LaRose, I got to ask you, my experience has been with receiverships that these are all fine and good, and the statutory bases are fine and good, but most of the time, at least pre-UCRERA, when you moved for a receiver, there was one thing that the trial judge wanted to see, and that was waste of one form or another, something that imperiled the property such that if a receiver wasn't appointed to preserve the status quo, that there might not be a property later down the road, or its value would be so severely diminished that there really wouldn't be an effective property. Has that been your experience or your observation?
My observation is that waste pre-UCRERA seems to be the necessary element to establish a receivership. And again, because receivership is an equitable remedy, by showing waste, you are balancing the rights in the property by the owner, who has a fundamental right to dispose or use his or her property, but you also are balancing it against the creditor who has loaned money based on the security of this property. So it is a balancing act, I think, to take care of those two interests.
Okay, right. Now, has there been your experience pre-UCRERA, Judge LaRose, that there was a difference in pre-judgment and post-judgment remedies and receivership? I personally have had the experience of representing a lender from another state who said, go ahead and get the receiver appointed, and pre-judgment, go ahead and sell the property. And I had to tell them, can't do that in Florida. What has been your experience with regard to sales of property post-judgment in Florida?
Well, I think
the different context.
The restrictions on pre-judgment sales, again, I think balance the equitable nature of receivership against the ownership rights. I think post-judgment, as the case law has fleshed out, post-judgment, the interference with the rights of the owner are much more diminished because your interest in interfering with that ownership right is virtually eliminated when you're at post-judgment, but the receiver is still there basically to continue to protect the property during the process of an appeal, if one is taken, and also during the stage of disposition of any property post-judgment. I think it is, your implication is prior to this statute, a receiver was not empowered under our case law to sell or otherwise dispose of the receivership property. And as we're going to hear, UCRERA makes some very significant changes in the ability of a receiver with court approval to dispose both in the ordinary course and outside the ordinary course of business.
As you alluded to, Judge LaRose, going on to the next slide, there's the Shube Hotels Boca versus FDIC case, which said that an order appointing a receiver could not grant the receiver the right to sell or otherwise dispose of the property pre-judgment, which I think was the law in Florida. My experience has been, as an advocate, that it was really sort of a free-form process, pre-UCRERA. Yes, you were writing on a blank slate, so you had some freedom to do certain things if you were a movant or if you were the opponent of the motion for appointment of receiver. But there were also concerns. This is an extensive appointment of receiver is an extensive remedy, and it does impact an owner's rights. So you know, the order itself, from my perspective, the order appointing receiver was really a big part of the battle because that's how you defined the rights and responsibilities of the receiver. Has that been your experience as well?
Absolutely. From what I've seen and from my perch, it is sort of an ad hoc approach. Every time you are seeking an appointment of a receiver, and you're basically going back and trying to create from scratch what our case law up to now has suggested. But again, I think two things that override that case law is the need to show waste, a reluctance to interfere fundamentally with the ownership rights in the property, and a great reluctance to allow a receiver to sell property.
Andrew, that takes us pre-UCRERA. I guess we can now talk about UCRERA's scope.
Yes. Right before we do that, I want to turn over to Kenneth Morena, who was the chair of the task force on this law. And Kenny, if you can give us maybe a couple minutes of how the BLS task force operated, and then as Manny mentioned, we'll jump right into the statute and start walking through the provisions.
Sure, thank you, Andrew. So just over 4 years ago, the Uniform Law Commission approached the business law section of the Florida Bar with this uniform law that they had prepared. And it was presented to the incoming chair, who was Melanie Damian, my law partner. And at the time, John Pollenberg was the outgoing chair. And at his last EC meeting, he created a task force to study this uniform law. And he appointed me and Amanda Fernandez as the co-chairs of this task force. And for the following 4 years, we worked first on determining whether UCRERA was something that would benefit Florida jurisprudence and the litigants and courts throughout the state. And then once we got over that hurdle, which took some work and discussions over the course of over a year, we decided to start revising sections in order to either bring them in compliance with existing Florida law or to make them make sense and somewhat consistent with Florida law and the ultimate goals of a receivership. And so as Judge LaRose explained, one of the big changes to Florida law that UCRERA makes is that it allows a receiver appointed under UCRERA to sell or dispose of property outside the ordinary course of business pre-judgment, which was a big source of debate within the business law section. But eventually everyone agreed that it was important to provide a receiver with that kind of authority in order to preserve the value of the property for the benefit of the litigants. And so once we agreed on that, we moved forward full steam ahead with various revisions. And we realized very quickly that it was important to include the real property section of the Florida Bar, as Senator Berman explained earlier. And so we invited them to participate in our task force. And we had one real property section member attend many of our meetings over the course of 2 years. And when we got to a closer point of having a final revision to the various sections we focused on, we sent them our revisions and we got feedback. In fact, Judge Mora and I did a pretty comprehensive presentation of UCRERA and our proposed changes to the real property section at one of their annual meetings. We got a lot of feedback and requests and questions that we fielded, and we addressed most, if not all, of their concerns in the course of our revisions that followed. And as we proceeded and further made those changes, we also reached out to the Florida Bankers Association, as Senator Berman said, and the Florida Land Title Association to get their input. And both of those organizations had changes that they requested, and we looked into their changes and we agreed with many of their changes and we made those changes. And after about 3.5 years, we felt like we had a near final version of the act that we were ready to present to the Florida legislature. And so with the assistance of Amy Diaz-Lyon and Doug Bell, we got sponsors to this act, and that was Senator Berman and Representative Beltran. And it was presented to the Florida legislature. And you know, by the time we got to the Florida legislature, most of the constituencies that would have an interest in the subject matter of this act had already weighed in and provided their input. And so it turned out that we sailed through the various meetings in both chambers with very little pushback, very little objections. And I'm happy to report that this act was unanimously passed in both chambers of the Florida legislature, and then ultimately signed into law by Governor DeSantis. So all of the panelists we're on the task force, and we're all very proud of what we and everybody involved in the process were able to accomplish. And we now have new Florida law.
Thank you, Kenny. With that, let's jump right into the statute itself and start looking at the provisions themselves. Kenny, the first one we have scheduled to discuss here is the scope of the law. And if you can tell us a little bit about that, and perhaps talk about that there is a difference in Florida law, the Florida law versus the uniform law, which is that first bullet, the word incidental, and kind of the question that comes to my mind, if you can address when you're talking about this, is what's the effect of falling outside of the law if this word incidental excluded the case from the statute? You know, what is the potential results there?
Sure. So this scope section, which is 714.04, is probably the section we spent the most time on, this and the sale outside the ordinary course, because we wanted to get it right? This is the section that determines what is and is not subject to the act. And the uniform law was, we thought we understood what it was trying to do, and that is make very clear that this was an act that would cover commercial real estate receiverships, and that residential real estate receiverships were not included, and that personal property, for the most part, was not included unless it was related to the real property, the commercial real property. And so as far as that first subsection of section 714.04, we added the word incidental, and this was at the request of the corporations committee of the business law section, just to make it abundantly clear that we're not talking, this act is not meant to be a receivership over personal property. It is personal property that might be related to and incidental to the actual property that is subject, the commercial property that is subject to the act. And so we added that word because and we added language further down in this section to make it clear that we're not talking about personal property. This is not a personal property receivership act, really. And so there's nothing more really to adding that word incidental, except to make it make that very clear. The next few subsections of section 714.04 was our rewrite to make it less confusing and easier to digest what we're trying to accomplish in this section of the act. And that is, the uniform law was presented as an exclusion of residential property, and then exceptions to that exclusion. And we went back and forth on whether to just tweak the exceptions to the residential exclusion, or to just rewrite the whole section, the whole subsection, to list the various exclusions and build into those various exclusions enough information so it's clear what, if any, exceptions might apply. So it's a lot easier in our minds to read and understand, having it the way that it is now in the law, and that is that subsection 2 is this chapter does not apply to, and then it lists the various exclusions to the act. Substantively, we didn't really change a whole lot from what the Uniform Law Commission had in their version, except that we narrowed it a little bit further. So we basically wanted to make it very clear that if the residential property could be used as commercial property, we wanted that to be an exception to the exclusion. We wanted that to be covered by the act so that someone couldn't skirt the law. So they couldn't take residential property, make it commercial property, and then somehow get around being subject to the law. And so that was a lot of the driving force behind our revision to this section of the act. And if you read, I won't read through it, but if you read through, you'll see that we just list the various exceptions. Now, I do want to highlight that what we changed with respect to the residential property exclusion is to make it very clear that it basically does not touch homestead property, which is sacrosanct in Florida. And the real property section of the Florida Bar really wanted us to make that very clear. And while we all agree with that, it wasn't in there. There was no statement that said this doesn't touch homestead property. So we specifically added a subsection that said, look, homestead property is not affected by this. Because if it's homestead, it's really not being used as commercial real property anyway. We also added in a section that made it clear that other Florida exemptions, where property would be exempt from the reach of creditors, should also be excluded, because those exceptions or exemptions under Florida law pertain to residential real property. And so we wrote that in there as well as one of the exclusions to the act. And then we also added in that any actions that are authorized by or commenced under federal law would be excluded from the act. Well, that language isn't necessarily required in a Florida statute because that is the law. Without UCRERA, we wanted to make it clear that UCRERA was respecting those types of receiverships, those types of actions brought under federal law.
Thank you, Kenny. I didn't mean to cut you off, but I do want to kind of keep moving to the next section. Judge Mora, can you talk to us a little bit about the notice and opportunity for hearing provisions of UCRERA?
Certainly, Andrew. This section 714.03 was revised pretty substantially from the Uniform Act to ensure that the Florida version would be consistent with Florida Rule of Civil Procedure 1.610B, and also to ensure that there was adequate due process protections that were addressed that would allow the courts to operate in a more flexible manner consistent with Florida's equity jurisprudence. Generally, this section requires that the court enter orders in a receivership case only after notice and opportunity for a hearing appropriate under the circumstances. And what this means really depends on what type of order is being entered during the case. if there is a run-of-the-mill motion, a motion to approve an interim receiver's report, and there's no response filed for that, the court has the discretion to dispense with a hearing, particularly if the notice of hearing specifies that relief may be granted without a hearing if no written response is filed by a date certain. The real focus as we were drafting this section was largely on whether or not the court could appoint a receiver without written or oral notice to the adverse party, to the owner of the property. And what was written into this statute that finally got enacted, different again from the Uniform Act, was that this concept of appointing a receiver without notice is only allowed under very narrow circumstances. The movant has to file an affidavit or a verified pleading that demonstrates immediate and irreparable injury, loss, or damage to the movant before any adverse party can be heard in opposition. And the movant's attorney has to certify in writing all the efforts that were undertaken to give notice to the adverse parties or the reasons why the notice shouldn't be required. This is very different from what was in the Uniform Act. This Florida version is much more detailed about what requirements have to be met to get a receiver appointed without prior notice. Now, if the adverse party appears at the hearing, the requirement of an affidavit or a verified pleading is excused, but of course, the movant won't really know that likely in advance, and therefore good practice would suggest an affidavit or a verified pleading be filed at the time that the receivership is sought. If an order appointing a receiver without notice to the adverse party is entered, there are a number of requirements that have to be met. The order has to specify not only the date of the order, but also the time that it was entered. It has to contain findings of fact which justify why the injury may be irreparable and why the appointment was made without notice. And the movant has to ensure that the order is promptly entered on the docket by the clerk of the court. Now, there are other requirements, not in this subsection, but in section 714.06 subsection 3 for the appointment of a receiver without notice that parties need to be aware of. They would require the movant, for example, to post a bond or other security unless the appointment occurs at the request of a governmental entity. And in that instance, the property owner or another party adversely affected by a receivership order that's entered without notice to the property owner can file a motion to dissolve that order of appointment, and the court is obligated to conduct a hearing on that motion within 5 days. Andrew?
Thank you, Judge. We will move next to the provisions governing the appointment of a receiver, which are the next two slides. Judge LaRose and Manny, back to you guys, if you can talk to us a little bit about these provisions and the effect of these on the, if you can address kind of, if you think this is a substantive change in Florida law as far as the entitlement to a receiver, or is this somewhat codifying what existing Florida law was, or it's too early to tell, and we'll have to see how it is interpreted.
I would like to think it's codifying, but it may be too early to tell. In 714.06, the statute maintains this dichotomy of an appointment before judgment and appointment after judgment. And as we were saying earlier, if it's a before judgment, what you're looking at is a situation where the property is impaired, where it's wasting, where it really makes the creditor's position very precarious. And I don't think the requirements of waste or diminution in value is going to change dramatically from our common law. After judgment, the receiver's task is a little easier. It's to carry out the judgment, preserve property pending appeal, or during post-judgment collection efforts. Manny, I'd be interested in hearing your view as a practitioner as to how the statute guides the trial court in deciding whether to appoint a receiver.
The statute is very good in this particular sense. One of the concerns we always had from the very outset in a receivership situation was the sort of amorphousness of the case law. You almost always, when you were doing a receivership hearing, ended up talking about Carolina Portland Cement, a case that's almost 100 years old, 90 years old. And so one of the true benefits of UCRERA is it standardizes the procedure. In effect, it takes that super detailed receivership order that a trial judge would enter and takes a step back and says, these are the things that you have to do in order to get that receivership instituted. One of the things that it makes it a lot easier and gives the trial court clarity is in the appointment of the receiver under 06. And the interesting thing, the thing that I like about the statute is that it really sort of takes us almost to a 365 type sale. Those of you familiar with bankruptcy procedure know that under 11 USC 365, there can be a sale of the property. Think of UCRERA, and this is my perspective, please don't attribute it to anybody else. But my perspective is UCRERA is almost like a half a bankruptcy procedure in that it allows a receivership to get in there and to preserve the property and allows the court to, in effect, take control of the property through the receiver and allows the court to preserve the property pending the sale of the property or the ultimate resolution of the case. And along those lines, the appointment of the receiver is wonderful. This was an area that was had a lot of discussion between business law section and the reptile section, as well as bankers, as well as FTLA, the Florida Land Title Association, and several other constituents, because they want to know when and what the court should consider. We've got the waste, if you can see on the slide, appointment receiver 71406, we've got the waste issue. Here's a significant one. Look at sub B. The mortgagor agreed and assigned record to the appointment of a receiver on default. I think that is a significant change, Judge LaRose, because those of us who did commercial receivership work in the past, we would have our 90-page single-spaced document which allowed for the appointment of a receiver upon default or upon certain triggers. And the trial court would say, all right, that's all fine and good, but you know what? Show me waste. I don't care what your document says, Mr. Farage. I want to see waste. Now it's in the statute, and those trial courts where they think there's an opportunity for them and it's in the best interest of the parties to do so, have a statutory basis for appointing a receiver. Keep going down the list. The owner agreed after default and assigned record the appointment of receiver. Look at the next one. Look at sub D under 2D. The property and other collateral are underwater. I think that's going to be significant. I think that is a significant change. Now, that was always something that we argued. Again, I don't know that it really got us much traction. I think the biggest traction any of us got that were seeking receiverships or whether the property had been properly maintained and or there was waste. The first part of that sentence pretty much entails the second part of the sentence. But this sub D is a substantial change because even though the trial judges may have thought about it, they really didn't have something to sort of hang their hats on. And then we've got the 69707 issue under E, the owner fails to turn over rents, the assignment of rents, or F, a subordinate lien holder obtains appointment of a receiver, meaning the second mortgagee or the third mortgagee or the fourth mortgagee gets a receiver. If so, then the first mortgagee is entitled to get a receiver. So I think that's going to make, well, to your earlier point, Judge LaRose, I think it may be a bit early to see how this is going to shake out, but I always got the sense that part of the challenge move its head in getting a receivership was the amorphousness of the case law, and that there wasn't an established practice or procedure. With the adoption of UCRERA, I think that particular issue is it goes by the wayside. There's a clear statute now, and if a trial court is inclined to appoint a receiver, the trial court can follow the statute. I think it takes away that particular issue.
I think that's
And
right.
I guess we're going to talk. I'm sorry, Judge Rubos?
I'll just say two other points about 06. This is not an exhaustive list of factors that the trial court has to look at. And just as a judicial point of curiosity, I am wondering if over time any of these factors are going to carry more weight than others.
Yeah, it's a good question. I think, at least in the early stages, I think judges are going to be, trial judges can be more comfortable with the waste issue or the lack of maintenance issue. But as the law progresses along these lines, and especially if you have sophisticated documents, which commercial documents typically are, which allow for the appointment of receiver, I think there's going to start to be a process where under appropriate circumstances, you are going to get the appointment of receiver, even if the waste component may not be as significant. That's my guess. Why? Because there's now a statute in place that says shall. And if the statute says shall, I think most trial judges are going to follow that instruction.
Thank you. Thank you. Judge Moore, we're going to turn to you for the next section, the receiver as a lien creditor.
Andrew, can I just point out one little comment on that?
Sure.
Section 06? So I just wanted to point out that the uniform law as presented to us was quite different. It didn't have a list of factors for a court to consider, but rather in its subsection B said that a party is entitled in a foreclosure action in particular, a party is entitled to a receiver if, and then listed a bunch of factors. And we weren't so comfortable with that because we wanted to make sure that the judges had adequate discretion to appoint a receiver, its receiver, under the appropriate circumstances. And so we changed it to making those factors to consider. And the other thing that we changed from the uniform law is that we added in substantial diminution in value to the list of factors to consider pre-judgment for the appointment of a receiver, not just waste, loss, impairment, but substantial diminution in value, which is something that federal receivers, for instance, consider all the time and use as a reason to sell real property before judgment.
Thank you. Judge Mora, we'll go to you now.
Thanks, Andrew. The next section we're going to talk about is section 714.09 that gives the receiver the status of a lien creditor. The way the statute reads, it says that upon appointment, the receiver has the status of a lien creditor under Chapter 679, which is Article 9 of the Ucc, as to receivership property and fixtures, and Chapter 695, which deals with real estate recordation, as to receivership property that's real property. Now, receivership property is expressly defined in the statute, and it includes, first of all, everything that is described in the order appointing the receiver, which at a minimum would be the real property and any personal property incidental to the operation of the property. Importantly, it also includes all proceeds, rents, and profits from the property. And so the best way to look at this, which is an entirely new provision, I think, under state law, is the similarity that this provision has to a provision in the Bankruptcy Code, which is Bankruptcy Code Section 544. In bankruptcy world, that section is referred to as the strong arm clause because it permits a bankruptcy trustee to assert a superior interest in the debtor's property that comes ahead of any unperfected security interest holder or third party or the debtor itself. So by suggesting that the receiver has this same power, the receiver should have the ability to claim a superior interest in all receivership property, including all rents, ahead of any unperfected interests or third-party claims or debtor claims to entitlement to the rents. Andrew?
Thank you, Judge. Appreciate that. Next, we're going to turn to Kenny and Manny to talk about two sections, the after acquired property and turnover section, as well as actually three sections, which is 714, 10, and 11, and then also the powers and duties of the receiver, which are now codified in the statute, and that is 714, 12.
I really like these particular sections, Kenny. I think one of the things that to sort of riff on what Judge Mora was saying with 544 is that people probably wonder how UCRERA affected other receivership rights or other rights of parties, especially secured creditors. And the statute is pretty clear, extremely clear, that if there is a perfected security interest, that predates the appointment of the receivership. That does not affect the right of that secured creditor. Did you have any pushback from anybody on that one, Kenny?
No, not at all. I think
Yeah.
everyone expected that and wanted that.
Yeah. And the second part that I like under point 11, part 11, is that again, sort of going over to sort of the bankruptcy side when a trustee is appointed or debtor possession is appointed. That debtor possession, that trustee can require the turnover of what is receivership property. Sometimes in state trial court practice, that was a little bit of a murky question as to, well, who owns it? Whose property is it anyway at this particular point? Point 11, part 11, makes it clear that it's a receivership property and you got to turn that thing over. Let's talk about the powers and duties of the receiver, which is subsection 12 or section 12. Here's what I like, is sub B, statutorily, a receiver can now operate a business which constitutes receivership property. That's a big issue with regard to real estate developments in Florida, right?
Yes.
And that was always a big question, is that, well, you know, what are the powers of that receiver? Are you actually really telling us, Judge, that the receiver can now run the property? I thought the receiver was being appointed to preserve the status quo, but now you're telling us that the receiver can run the property. And I tell you what, yeah, my client may have been not a great operator, but I guarantee you that my client, who's a developer with 40 years of experience, probably has a better chance of making this property profitable than some lawyer like Manny Farage, who just got appointed as receiver in this particular case. And those are the types of arguments that you got, but now it's right in the statute. Do you think this is going to be a significant change in the practice of state court receiverships?
I don't know that it will be. I think that a lot of receivers, if they aren't granted this power when they are appointed over commercial real property, would go back to the court immediately and say, I need to be able to operate this property, which is the subject, the very subject of this receivership. And so one of the reasons why we all agreed that in the end that UCRERA was necessary is because it was never that clear in those initial appointment orders exactly what a receiver is supposed to do, or whether the parties and or the court really considered all of the things that the receiver needed to do to fulfill the role of a traditional receiver over real property. And so this section is going to be one of the most cited sections in most receiverships that are spawned from UCRERA, because it does identify all of these powers that a receiver has right out of the box. Immediately upon inception of the receivership and the appointment of the receiver, without further court order, unless specifically limited by the court, these are the things in the first subsection of this 714.12. These are the things the receiver can do, and they all revolve around doing things in the ordinary course of the business of the commercial real property. Then there's another section below which says what a receiver may do, and it's with court approval. And finally, there's a section that says this is what the receiver shall do, listing all of the duties of the receiver. So again, I think this will be cited in the motion to appoint a receiver of all the things the moving party wants the receiver to do, but also hopefully end up in those orders appointing the receiver, so it's abundantly clear what the receiver can and cannot do.
One of the things I really like about 714.12 is it's borrowing from the 2004 process, which is the bankruptcy process for obtaining depositions, and it gives the receiver the power to jump in there and start to get records. The problem we have, well, when a receiver is appointed, a lot of times is that the dispossessed party, whoever that may have been, the owner, is probably not going to be very cooperative with regard to the receiver. And it's not going to give up a lot of records, and it really hamstrings the receiver in being able to operate and preserve the property. The statute now gives the receiver the ability, upon subpoena, to compel that person to submit to a deposition, and also to incur unsecured debt. Now, I suspect most trial judges are going to say you can incur unsecured debt within a certain amount, meaning if it's going to be over $1,000 or $5,000 or $10,000, whatever, you need to come back to me. But I think that also makes it a lot easier. To your point, Kenny, powers and duties of the receiver under 112. With court approval, a receiver can incur debt other than in the ordinary course of business, make improvements to receivership property, use or transfer receivership property other than the ordinary course of business pursuant to 0.16. And here's the one that really stuck out at me throughout this process. Adopt or reject an executory contract of the owner pursuant to 714.17. You're almost talking pure bankruptcy law at that particular point, aren't you?
Yes.
Almost, Manny. Not quite.
Almost. We're not taking over your job, Judge. Don't worry.
Well, thank you. I think that's a really good segue into the next provision, which is Judge Mora. The statute talks about the duties of the owner now and has codified that.
Thanks, Andrew. Section 714.13, Florida's version of the UCRERA statute, is virtually identical to the uniform statute. And in many ways, this does mirror the section in the Bankruptcy Code that imposes obligations on a debtor in terms of cooperating with the trustee. Here, the owner of the property has the obligation to assist and cooperate with the receiver so the receiver can do what the receiver has to do. The owner also has the obligation to preserve and turn over all the receivership property that the owner either possesses or controls. And they have to identify for the receiver all the records and other information that relates to the receivership property, including things like giving over passwords or authorizations or other information that will allow the receiver to have access to and control over the receivership property. Turn over all custody or control. Manny was alluding a few minutes ago to the requirements under the Bankruptcy Code under section Federal Rule of Bankruptcy Procedure 2004, where a trustee can take expansive discovery of the debtor. Well, here the owner has the obligation to submit to an examination subject to a subpoena being issued, submit to this examination under oath concerning the acts, conducts, property, liabilities, and financial condition of the owner, and any other thing relating to the receivership property. The owner's got to perform any duty that is imposed on him by the court, by the statute, and more importantly, when the statute talks about the owner, the statute now makes clear that if the owner is an artificial entity, anyone other than an individual, that every control person, every officer, director, manager, member, partner, trustee, anybody who has control over the affairs of the owner is obligated to serve in this role as facilitating the acts of the receiver in its role. And most importantly, the statute says if the owner or owner representative doesn't fulfill its duty to assist the receiver can seek actual damages caused by that failure and get a court order sanctioning that failure for civil contempt. Andrew?
Thank you, Judge. I will note we're at 1 o'clock, 1:02 p.m. We are going to go a little bit over. I think we're kind of getting through the substance here. We may not be able to reach questions today, but we're going to continue to go on for a little bit after our hour. Judge Mora, we'll stay with you to talk about the next two slides, which are the permissive stay that a receivership court can enter.
Thanks, Andrew. Let's talk about the stay and Kenny said that there were a number of different provisions that were really mucked with by the task force. This was definitely one of them. And I want to point out why that is. You know, the concept of an automatic stay really is something that people who do bankruptcy are very familiar with. As soon as a bankruptcy petition is filed, the automatic stay goes into effect. You got to stop what you're doing. You can't take any enforcement action at all with respect to your debt. Here, you've got a proceeding that is different than a bankruptcy. A receivership often starts out as a two-party action. You've got the mortgagee and the mortgagor. And it may be that the rest of the creditor constituency that the mortgagor has isn't aware of the pendency of the receivership. And so when the subcommittee that looked at this particular provision from the Uniform Act thought about how those two proceedings were different, a bankruptcy case from a receivership, it really made sense to us that we had to ratchet back what it was that the stay in a receivership looked like and how it could affect creditors. So the first thing that's different is that the stay that arises in a receivership is not a mandatory stay. It's not automatic like in a bankruptcy case, and it's not automatic like is provided for in the uniform.
I cannot hear Judge Mora's audio right now. Can anyone else hear her?
I think she may have locked up for a moment there, Andrew.
Yes, I believe that we actually lost the connection for Judge Mora, so I'm working on seeing how we can get that back up and running quickly.
Okay, what we'll do in the meantime is we will move forward to the, and hopefully circle back when Judge Mora is back online, but move forward to Judge LaRose and Manny in the concept of sales of the receivership property. And that is, I will move forward to that and hand it over to Manny and Judge LaRose.
Judge Rose, looks like we've got this dichotomy before sale, or excuse me, before judgment and after judgment, continuing into 714.16. So we've got a sale before, permitted before the receivership, if the owner expressly consents or the owner fails to object within a certain period of time, a sort of negative notice provision. And after judgment, again under .16, the receiver can transfer receivership property outside the ordinary course of business, quote, to carry the judgment into effect or to preserve non-exempt real property pending appeal or when execution has been returned. And there's got to be a specific sort of notice given. That particular provision was put in there to protect at the insistence of the real property section. What are your thoughts on this particular section, Judge Rose? Again, we're almost like a bankruptcy 365 process here.
It is. I think it is a bellwether change for our common law of receivership. But again, when we go back to before judgment, the owner can consent, the owner can fail to object after getting written notice, but again, the burden remains on the movant for the receivership that the sale in the outside the ordinary course is necessary to prevent waste, loss, diminution in value. So that concept, even for a sale outside the ordinary course, remains intact.
Exactly. And the interesting thing, if we can finish this concept, Andrew, then we'll turn it back over to you to get Judge Mora back on, is the sale free and clear of liens provision. Again, 714.16, the court can order that the property is going to be sold free and clear of liens on the property with the proceeds attaching to the sale. Now we're completely into Judge Mora's wheelhouse because this is a bankruptcy provision. This is 311 USC 365. This, I think, is going to be a significant change, and this is one of the things that Florida Land Title wanted. Obviously, if you're going to have that sale, you're going to want to be able to sell that property free and clear of liens. That really makes it a lot easier to transfer properties. I think it'll make it easier to transfer these properties in these particular situations and speed up the process of rehabilitation of these properties or the receivership clearing up the disputed issues. What are your thoughts on that, Judge?
Absolutely. I think that is going to make it a much easier process for selling the property. But again, it's not a foreign concept to Florida law. I mean, think of construction or mechanic lien problems. There are always ways to bond off those kinds of claims on the property, and the other lien holders have their access to the bond. And here we have other lien holders having access to the value of the sale after it's completed.
Thank you.
Yeah,
Thank
yeah.
you. Judge Mora, I think we have you back. My thought would be to give you an opportunity to kind of finish your thought on the stay, and then you were next on slide 25 to talk briefly about executory contracts here and the uniformity application, and then we'd be done to talk about the effect on the practice going forward.
Certainly. Let me finish up on the stay. I think the point I was trying to make when my internet went down is that the stay in the Florida version of UCRERA is a permissive stay, meaning that the movant has to request that the stay be imposed. It's not going to be automatic like it is under the bankruptcy code. The stay, if ordered by the court, will prohibit any person from obtaining possession over or exercising control over the receivership property, and that would include enforcing a judgment against receivership property. The stay also prohibits any person from enforcing a lien against receivership property, with the exception, of course, being for the mortgagee who sought the receivership to commence the action. And the stay order, again, with the concern that you had a proceeding that initially was just between the mortgagee and the mortgagor, there wasn't the same kind of party involvement of all creditors like you have in a bankruptcy. The concern was that if the stay went into effect, that people would be properly notified of it who might unintentionally violate the stay. And so we even wrote in to the statute that the stay order has to have a special title, order staying certain actions to enforce claims against receivership property, so that parties who were not initially part of the receivership action would get proper notice that, hey, something is up here and they can't just proceed in the ordinary course. Now, subsections 2 and 3 of section 714.14 provides that the court can enjoin any act, action, or proceeding against receivership property if it's necessary to protect against misappropriation or waste, but you have to describe in reasonable detail the act or acts restrained within the order itself without just referring to a separate pleading or other document that a non-party to the action might not have in their possession. And in order to be bound by the stay, a person has to actually receive a copy of the order. They have to have actual notice of the stay, or they have to be acting in concert with a person who has actual notice. Again, these provisions are provisions that are unique to the Florida version. Now, if somebody is adversely affected by the stay, they can file a motion for relief from the stay, and the court's obligated to hold a hearing within 5 days or such time as the court determines is reasonable and appropriate. And it's interesting because you might contrast that with the periods of time that are contemplated for stay relief motions in bankruptcy court, where a motion has to be heard within 30 days, and that could be an initial hearing, and then there could be another 30 days before a final disposition of the motion for stay relief actually gets heard. Now, there are bankruptcy-like exceptions to the stay or injunction. Those are things like acts to perfect or continue the perfection of an interest in receivership property. There's an exception for criminal proceedings, for governmental actions to enforce police or regulatory powers, or an action by a governmental unit to establish tax liabilities. Again, this subsection is unique to the Florida version. One more thing that it makes sense to point out here is that the language in subsection 6 of the stay provision says that the court may void an action that violates the stay. That means that acts are voidable. They're not void ab initio, which is always a big discussion in bankruptcy cases. Did a creditor do something that's entirely void from inception, void ab initio, or is it merely voidable after the court reviews it? And then finally, one last point is that any party that seeks entry of this type of stay may have to post a bond or alternative security. Okay, let's move on to the next concept, which is executory contracts. Now, executory contracts are something that is very familiar to bankruptcy lawyers. Those who are familiar with the bankruptcy code provisions on assumption or rejection of executory contracts and unexpired leases will note some marked differences between the rights of receiver compared with those of a bankruptcy trustee, as those rights pertain to these kinds of agreements. First of all, what is an executory contract under Chapter 714? Well, that's in the definition section, not in 714.17, but in 714.02. And it provides the following definition, which is that it's a contract, including a lease, under which each party has an unperformed obligation, and the failure of a party to complete performance would constitute a material breach. Well, that's a lot of words, but that is the historical definition of executory contract that Professor Countryman came up with many years ago that was often cited by bankruptcy courts. Another test was developed, which actually is in force in the 11th Circuit, which Florida is a part of, the federal 11th Circuit, which is called the functional test. And it's just another way to think about these kinds of contracts. And the issue under the functional test is, would the assumption or rejection of the contract or lease benefit or burden the receivership estate? If no benefit can be derived from assuming or rejecting the contract, then it's not executory. The other thing to note about executory contracts under the Florida version is that this also applies to timeshare interests. So what 714 says is that executory contracts that are not adopted within a reasonable time after the receiver's appointment are deemed rejected. Now, note, there's no firm time frame like there is under the Bankruptcy Code within which a receiver has to adopt or reject an executory contract. And also, rather than using the Bankruptcy Code terminology of assumption of an executory contract, UCRERA has chosen different terminology, the word adopt. Rejection of a contract, just like in bankruptcy, is deemed to be a breach of the agreement on the day preceding the appointment of the receiver. What's significant about that? Well, if the receiver, who now has stepped into the owner's shoes with respect to this agreement, is deemed to be in breach, it means they can't enforce the agreement, and the counterparty to the agreement can enforce their rights and remedies under that agreement. But what does that really mean? It means, just like in bankruptcy, that the counterparty can assert rejection damages against the receivership estate, and those have to be filed within 30 days of the order approving the rejection of the contract, or the date that's set in the rejection order, whichever is applicable in that particular instance. One thing to note, that clauses in agreements that are known as ipso facto clauses that purport to curtail the right of a receiver to assume the agreement or adopt the agreement, or purport to terminate the agreement upon the appointment of a receiver are deemed unenforceable under subsection 4 of section 714.17. Now, if the owner has the right to assign an agreement under the laws of this state, then if the owner has that right, then the receiver likewise has the right to adopt and assign the executory contract. This is obviously a much more limited right than exists in the bankruptcy case scenario, where a trustee pretty much has an unfettered right to assume and assign an executory contract or an unexpired lease, so long as the assignee can demonstrate the financial ability to perform under the lease, and any default under the contract is cured prior to assumption and assignment. And one could envision that when receivers attempt to exercise this right to adopt and assign, that those concepts from the Bankruptcy Code of ensuring that the assignee can perform and that all then existing defaults are cured may be borrowed into the statute in a receivership case. Now, the rights of tenants, purchasers in possession of real property, and purchasers of timeshare interests are protected. What does that mean? It means if the receiver chooses to reject an executory contract with any of these parties, those parties can choose to remain in possession of the property so long as they perform under the agreement. To the extent the receiver fails to perform, the counterparty, that party in possession, can offset their damages against payments due under the agreement. What they can't do is they can't obtain affirmative relief against the receiver or the receivership estate for those damages. And one last point, there was always this concept of ensuring that this statute wouldn't be used adversely against people who were using property as their homestead or were individuals. And so a receiver cannot reject a lease under the statute with a tenant that utilizes the property as the tenant's primary residence, so long as the mortgagee knew about the lease, or the mortgage was subordinate to the lease, or the lease was commercially reasonable when it was entered into, and the tenant didn't know that the lease violated the terms of the mortgage. Andrew?
Yeah. Thank you, Judge. There's one final section here that I'll kind of go through very quickly, which is the uniformity in application and construction. There's a statutory intent here that a court can consider other similar laws when interpreting the Florida version of this law. I think the practice pointer here at the beginning of the materials, we talked about the other states that have enacted a version of this uniform law. And I think as this law develops in Florida courts and there's disputes over specific provisions, it may be useful not just to look at Florida law, but it'll be useful to look at these other states that have adopted it and what have the courts ruled there. And to the extent, we've talked about a lot of the Florida specific provisions, but there's a good chunk of this law that is still a uniform act. And then to the extent there's another state that has interpreted that uniform provision in a certain way, this section seems to indicate that that would be persuasive to a Florida court interpreting essentially the same language. So just a practice pointer there. We will move now toward kind of the end of our presentation. We have a couple slides left. Judge LaRose, I'm going to skip this first one. I think we've adequately talked about the entitlement to appointment of a receiver today, but I'd like to talk about the second two bullet points. The first of which is kind of a practice pointer for Manny and Kenny. As a practical matter, when you're going into your receivership hearing, how does this affect that? In your receivership order, we're all used to seeing these long receivership orders that laid out for example, the receiver's authority and a lot of the things that are now codified on in the statute. Are you now taking that receivership order and paring it back, or are you keeping it and saying the receiver has everything in the statute, including but not limited to, and then keeping your existing receivership order? Can you talk to us a little bit about what you think the result is here?
Here's my perspective. I think there's an additional step that you need to take, the party's going to need to take in light of UCRERA, and that additional step is that you need to have that conference with your client and say, here's UCRERA, here are the default provisions, this is what we're going to get, most probably, unless the court finds some way to not follow a particular statute section. So you tell me those particular provisions that are really going to be problematic for you, and then let's deal with that. For instance, a particular party may want the automatic stay that Judge Mora spoke about to be in effect. If so, then you're not going to rely just on the statute. You're going to try to get in there real fast, real soon. In terms of the actual bank receivership hearing and the receivership order, I think UCRERA is going to make it easier for trial judges to get over their reluctance to enter receivership orders and to enter more complex and sophisticated and well-tailored receivership orders that meet the requirements of that particular case. That's my thought on that. What do you think, Kenny?
I completely agree. I would just say that from a practical standpoint, if I were filing a motion to appoint a receiver under UCRERA, as I mentioned earlier, I would most certainly cite to both subsection 12 and subsection 6, but I would list most, if not all, of the powers and duties of the receiver in my motion, and most certainly in my order appointing, the proposed order I submit to the court, because I would want an order that becomes like the law of that case from the perspective of the receiver, but also puts on notice third parties of what the powers and duties of the receiver are. Because having served as a receiver and counsel for a receiver in every single receivership, I have to send that receivership order to third parties asking that they comply with the order or turn over information or documents or property. And I don't want to have to also send them a copy of the statute and say, here, read my receivership order and the statute so you know exactly what you are required to do to be in compliance. I would like it all in that order so I can hand that order to everyone. And it's really not that hard to just paste into the order all of the powers and duties.
That's a good point. You're also going to probably get a certified copy of the order appointing receiver and record that certified copy so that the title record makes it very clear the powers of the receiver and what the receiver is doing. I think that's very good advice. Andrew?
Thank you. Judge Mora, we'll go to you. You can give us your thoughts, a for a couple minutes here on this last bullet point before we close, kind of your thoughts on how this new law affects other insolvency options.
Certainly. Look, it's important to point out that there's a real difference between a receivership proceeding and the other things that are listed on this slide. Obviously, receivership proceeding is going to be commenced by the creditor mortgagee. These other insolvency options, a wind down and dissolution, an assignment for the benefit of creditors, bankruptcy, a UCC transaction, these, many of them, other than the UCC transaction, are normally commenced by the debtor borrower. So, for example, wind down and dissolution normally would have to be done with the consent of the mortgagee and would likely entail a disposition of the property. So it'd be a cooperative act between the owner, who would remain in control and handle the disposition, cooperative act with the mortgagee consenting to the disposition happening in that way. Frankly, in close to 40 years of practice, I've never seen that. An assignment for the benefit of creditors is, for those who aren't familiar with that, a state court insolvency proceeding under Chapter 727 of the Florida Statutes. In that type of proceeding, the mortgagor or borrower would assign the property to a third-party fiduciary known as an assignee, and that party would liquidate all the property of the mortgagor for the benefit of all creditors. Now, generally, a secured creditor has to consent to an assignment proceeding because there is no automatic stay in the assignment case that would preclude the secured creditor from proceeding with an enforcement action like a foreclosure or even a receivership. But if the mortgagee doesn't want to take title to the property, an ABC is another vehicle by which a third-party fiduciary can sell the mortgagee's property. And depending on whether there's ancillary property at the mortgagor's real property that would be valuable to a buyer who acquires the real property, and the mortgagee perhaps doesn't have a lien on that property, then use of an assignment for the benefit of creditors may enhance the value of the mortgagor's collateral. Bankruptcy would also have to be initiated by the mortgagor, generally because a mortgagee often wouldn't qualify as a petitioning creditor unless the mortgagee was undersecured by at least $16,000 or so. And if the mortgagor has 12 or more creditors, the mortgagee would have to enlist 2 other petitioning creditors to join in the involuntary petition. So it's generally going to be a proceeding that's commenced by the owner. In a Chapter 7 case, the Chapter 7 trustee would be charged with disposing of all the estate's property to maximize the recovery for all creditors, although the secured creditors are paid first from the proceeds of their collateral. In a Chapter 11 case, the mortgagor would stay in control of its property as a debtor in possession, and generally, and could delay a sale of the property for many months while it attempts to structure a reorganization plan. Now, as a final note, costs of a bankruptcy case, I'm sure you won't be surprised to hear this, often tend to be much higher than in a receivership. And the reason why is because the trustee or debtor in possession also has to address issues arising from the debtor's relationship with other creditors because of the trustee or debtor in possession's need to dispose of other assets or their need to pursue other litigation. So those cases, bankruptcy cases, are generally not just about the property that is the focus of a receivership action. Now, finally, a UCC transaction. All right, that involves a secured party who conducts a UCC foreclosure sale with or without the consent of the borrower. That also may not be really analogous to a receivership, because usually a UCC transaction is only used for personalty and can't be used to transfer title to real estate. However, if the mortgagee also has a lien on the equity interests in the mortgagor, then a UCC transaction may be a viable alternative to effectively transfer ownership of property, so long as the secured party can convince a buyer that the buyer isn't also acquiring unknown liabilities of the mortgagor other than those associated with the mortgage debt. For example, under commercial mortgage-backed securitization loans, the mortgagor is not supposed to own any other property other than the property directly related to the real estate. And so in those kinds of loan facilities, it may be somewhat easier, and is often, frankly, found in a restructuring, that there is a sale of the equity, and it can be done through a Ucc transaction, a sale of the equity in the owner of the real property when you're trying to transfer title and the mortgagee is trying to realize value. But that's the kind of scenario where I envision a Ucc transaction might be an alternative to receivership action, and it again requires the mortgagee to have taken as additional collateral not only the mortgage, but also a lien on the equity of the mortgagor. Andrew?
Thank you, Judge. I want to first of all mention the materials today, the slides. I believe they're going to be available on the Business Law Section website. If you also want a copy, feel free to email me. I will send them to you. And then I want to say thank you to our panelists. All four of these panelists were on the task force and have spent, as you heard from Kenny, 3, 4, 5 years working on this law and taking it from an idea really through reality. And really want to say thank you to them, not just for serving today and prepping for this, but really for the years that they poured into this. Also, Kenny, who chaired it, I know has spent an incredible amount of time making this a reality. So to close, I did want to give each of you a few seconds to say anything you'd like in closing. If you have any thoughts you'd like to say, we can just go down the line here, and then after that, we'll conclude. We'll start with Judge Mora.
Well, I'm delighted to see the state judiciary have access to the same kind of statutory-based framework that we bankruptcy judges have. It's often very comforting to look at a statute that tells you what you can do and what you can't do, and gives you the parameters within which a particular type of litigation is proceeding. So I think it's a great advance for receivership law in the state of Florida that UCRERA, in the form that it was ultimately fashioned in, became enacted. And I personally want to extend my thanks to Kenny for his great leadership over these many years. I want to point out, I was not always a bankruptcy judge. I was a practitioner when I started this process. And, I often thought about whether it would be somewhat weird as a judge, bankruptcy judge, to continue working on a statute that I was never going to be involved in enforcing. But having already invested as many years as I had, I couldn't leave Kenny in the lurch. So thank you, Kenny, for all your service.
Thank you, Judge.
Judge LaRose, you're up next on our list here.
I also want to provide accolades for Kenny, who's done a great job of shepherding this. I think the statute does provide much needed guidance and cabining, if you will, for our trial judges dealing with receivership issues. I am really looking forward to people like Manny and Kenny to tee up some issues as they arise, and I can let you know.
Thanks, Judge Manny.
First, a mea culpa. I got an email saying that I referred to 363 by calling it 365. That's 11 U.S.C. 363, not 365, sale or disposition of property in the bankruptcy code. So I'm sorry about that. I'm excited about UCRERA, not because it means that every case is going to get a receiver. Not every case deserves a receiver. That's the long and the short of it. But it's going to get parties to the place where they should have been in the first place, and that is getting receiverships in place when the facts and the law and the contracts call for it. If we have one of those types of situations, it's going to make the job of trial court judges that much easier it's going to make the job of advocates such as ourselves much easier, because we're going to be able to now advise with some level of certainty that this is what's going to happen if we have a receivership hearing, whether we're representing the movement or the party opposing the movement. So all the way around, I think it's going to be a benefit for the citizens and the businesses of the state of Florida. I'm really excited to see it come to fruition, and I'm really excited to see it start getting applied.
Thank you, Manny. And now to the chair of the task force, Kenny.
Thank you, Andrew. I agree with everything that my fellow panelists just said about the law and the benefit I think we all expect it to be and add to Florida jurisprudence, especially given the timing and how it might be needed more than ever right now and for the next 18 months or so. I do want to recognize the task force is not just the four of us, but there were 12 or 13 members that were involved from the very, very beginning, and we all worked very hard together over that time period. And I just want to mention a few people, and that is my co-chair, Amanda Fernandez, Diane Wells, Adina Paulin, who was on the task force and also went to Tallahassee and attended some of the committee meetings. Keith Bell did the same in Tallahassee. Zach Hyman, Amir Isaiah, Don Workman, Doug Bates, Lynn Sherman, and David Peterson were among the most active participants in the task force, and they deserve equal credit.
Thank you, Kenny, and thank you everyone for attending today and for your patience as we ran a little over. With that, we'll be adjourned. Thank you.